Disputing credit card charges. There are few things more frustrating than when incorrect payments or charges appear on your credit card statement. Perhaps you've been charged multiple times for the same item, charged for an item you never received, or a payment has failed to be credited to your account. If you notice activity on your credit card that you have not approved or believe to be false, you should know your rights and fight back to correct these errors. Under the Fair Credit Billing Act (FCBA), there are dispute settlement procedures that you can undertake. These are applicable to any open-end credit accounts, such as credit cards, plus revolving charge accounts, like department store credit. However, be aware that these procedures do not apply to installment contracts such as loans or extensions of credit repaid on a fixed schedule. Applicable types of errors. The FCBA covers billing errors that may have resulted from, or include, any of the following. Unauthorized charges. Federal law limits your responsibility for unauthorized charges to $50. Charges that list the wrong date or amount. Charges for goods and services you didn't accept or that weren't delivered as agreed. Mathematical errors. Failure to post payments and other credits, like returns. Failure to send bills to your current address, assuming the creditor has your change of address, in writing, at least 20 days before the billing period ends. Charges for which you ask for an explanation or written proof of purchase, along with a claimed error or request for clarification. Initiating a dispute. To ensure protection under the law of the FCBA, you must contact the creditor at the address given for billing inquiries. This will most likely be different from the address you usually send your payments to. Provide them with your name, address, account number, and a description of the billing error. Your letter must reach the creditor within 60 days of you having received the initial bill that included the error. It is strongly advised that you send any correspondence by certified mail so that you have proof of receipt. Include copies of any evidence that supports your claim, keeping any original documents for yourself, and always keep a copy of your dispute letter. The creditor must reply and acknowledge your claim within 30 days of receiving it, unless the issue has been resolved by then. The creditor has a maximum of 90 days or 2 billing cycles after getting your letter in which they must resolve the dispute. During the investigation. While an investigation is in progress, you may withhold payment on any disputed charges but must continue to pay any part of the bill that is not in question. A creditor cannot take legal action against you during the investigation period, nor can they close or restrict your account. They can, however, apply the disputed amount against your credit limit. They can also report that you are challenging your bill, but they may not threaten your credit rating, report you as delinquent, accelerate your debt, or take any discriminatory action against you, such as denying you credit because you have disputed a bill using your rights under the FCBA. If the creditor admits that they have made an error, they must explain to you in writing what corrections will be made to your account and remove all finance charges, late fees, or other charges related to the error. Should the creditor insist that you still owe them a portion or all of the disputed amount, they must explain to you in writing how much you owe and why. You can request copies of any relevant documents. At this point, you can either decide to pay the requested amount, which may include finance charges that have accumulated whilst in dispute and any minimum payments you may have missed, or you can refuse to pay. If you refuse, you must write to the creditor within 10 days, indicating your refusal to pay. The creditor may then begin collection procedures or report you to a credit reporting company as delinquent. They must inform the credit reporting company that you don't think you owe the money and must tell you who has access to the reports. Any creditor who fails to follow the procedures set out in the FCBA, for example if they do not respond or take action within the allotted timeframes, will forfeit any disputed amount up to the value of $50, even if the bill turns out to be correct. This penalty also applies if a creditor threatens to report, or improperly reports your failure to pay during the dispute period. Disputing quality of goods and services. Disputes about the quality of goods and services are not covered under the FCBA's dispute procedure as they do not qualify as billing errors. However, if you paid for faulty goods or services with a credit or charge card, you can take the same legal actions against the card issuer as you can take under state law against the seller. In order to do so, you must have made the purchase of more than $50 in your home state or within 100 miles of your current billing address, and make a good faith effort to resolve the dispute with the seller first. The dollar and distance limitations don't apply if the seller also is the card issuer, or if a special business relationship exists between the seller and the card issuer. Additional rights and information. In addition to following billing dispute procedures, companies that offer open-end credit must give you a written notice when you open a new account and inform you of your right to dispute billing errors. They should also provide a statement for each billing period in which you owe, or they owe you, more than $1, or on which you have been charged a finance charge. Creditors are also required to send you your bill at least 21 days before your payment is due for credit cards, and at least 14 days before a minimum payment is due to avoid being late for open-end credit, even if no grace period exists. All payments to your account must be credited on the date they're received, unless no extra charges result from a failure to do so. Creditors must set reasonable rules for making payments, such as a reasonable deadline for a payment to be received and credited on the same day. They must also promptly credit or refund overpayments and other amounts owed to your account when you are owed more than $1. If you prefer a refund, a creditor must send this within 7 business days of receiving your written request. Further action. The FCBA is enforced by the Federal Trade Commission for most creditors but not banks. If you believe a creditor has violated the FCBA, you can register a complaint with the FTC. You can also sue them in court and may be awarded damages plus twice the amount of any finance charge, between $500 and $5,000 if you win. Higher amounts may be awarded if a pattern or practice of violations is determined. The court also may order the creditor to pay your lawyer's fees. If you found this information helpful, don't forget to leave a like and share the video. You can also subscribe to iDispute and turn on notifications to stay up to date. Thanks for watching.